Let the matter be called up. It's item 1.
No.
Wait for your turn.
Please, Your Lordship, I'd like to mention item 5. I'm appearing on behalf of PKQR. He's having some.
You wait for the matters to be called up. Who's for the respondent?
10 to 19 months. As per my instruction, my lord, the petitioner got voluntary retirement.
He wanted promotion.
My lord, already got a voluntary retirement.
Please, Your Lordship. I may be allowed to call my senior.
You are appearing for the petitioner.
Hello.
Tell me. Mr. Patgiri says that you have already retired. Voluntary, you have applied for voluntary retirement.
My Lord, I'm extremely sorry. I'm for the respondent.
You are for the respondent,
Yes,
all right.
Oh,
As submitted by Mr. Patgiri, Learned Counsel for the respondents,
10 to 19 months.
10 to 19. Who is for the petitioner here?
Name shown, madam. Madam.
They do- We'll take it up after a while. Who's for the respondents? Public Works. PWD. It's a seniority issue.
We thought it's social welfare.
25.
In these issues, Lordship, these are all 2012 matters, Lordship. We are not having the brief right now. We have to reconstruct the paper. Right now.
No, reconstruct is okay. The prayer is for setting aside the seniority list.
Lordship.
So you just get the input whether it has been rectified
Lordship.
or subsequently it has been
Probably it has been addressed, Lordship. Lordship, I will go through the file, Lordship.
You
and
please go through and we'll take it up again on Thursday.
Not on Thursday, Lordship. Lordship will, after opening, Lordship, in the meantime.
Let it be on Thursday. We'll see.
Thursday, I'll be-
You obtain Thursday. You're not available.
I'll be out of session. Thursday at Praja.
And then on 7th,
Lordship, 7,
7th, on 7th, enabling Mr. Nayak to obtain the instructions from the department. Item 25.
Lord.
Then 26, 27,
So this is the same matter, I think.
Same.
And I'm
25 to 27, fixed on 7th. Social welfare.
Yes, Lordship.
Yes.
But there is only, in our affidavit, we have stated that the petitioner Lordship, he is running the center well, but there are allegations, Lordship, allegations and counter allegations. And this was also interference of the Honorable MLA of the Golokganj LAC also has been sought for. So the higher authority of the Social Welfare Department, Lordship, they have stepped into for maintaining peace and all these things. And in the affidavit in reply, Lordship, they have not denied these things.
Sorry. Yes.
The present status, Lordship, I am not aware of, Lord.
You have filed an affidavit.
Yes, Lordship, affidavit is filed. It was on May 2012, Lordship.
He is not here.
And thereafter, they have filed an affidavit in reply also, Lordship. It says-
Affidavit by respondent 5.
Yes, Lordship, respondent number 5.
Okay. Who is respondent 5?
Lordship, CDPO,
CDPO.
Lordship, CDPO Golokganj.
So she was removed. She was removed.
No. Lordship, I fix it up on Monday, Lordship, so that I can get the updated status and appraise your Lordship on this,
All right, 7th.
Lordship.
List on 7th, enabling MS Bhattacharya, additional senior government advocate, to obtain required instructions in the matter.
Deeply obliged.
Yes, where is the petitioner? Their application was rejected. Their case was rejected.
Lordship, actually, this matter has been handled by Mr. B. Gogoi, Lordship. So,
Yeah, where is Mr. B. Gogoi? Call him, call him. Call him at 2.
obliged.
At 2, Namketa Didi ko. Council for the-
May I please, Lordship? Lordship, I'm seeking an adjournment in this matter, Lordship.
Sorry.
I'm seeking an adjournment in
Why?
this matter, Lordship, on behalf of Mr. D. Nath, AP, respondent number 4, your Lordship. Lordship is suffering from a medical issue.
Is that common cadre?
Yes, your Lordship, common paper.
Yes, madam. At the request of Mr.
Lordship, HR da.
H.R. Das, matter stands adjourned for 3 weeks. MS so-and-so learned counsel appears for the petitioner, does not object. List after 3 weeks.
Obliged.
Obliged.
May I please?
Yes,
Where my lord, the petitioner has not given the promotion my lord, from the post of constable to my lord, ASI my lord, UP my lord. On the grounded my lord, one criminal case is pending of 2006 my lord. Here in the present case my lord, two different proceeding has been initiated my lord. One is still pending. And as per the affidavit, they said it is going to be disposed of, and one is disposed of where punishment is of my lord, stoppage of one increment for whole life. Now, by way of affidavit, my lord, they said that it should be stoppage of one increment with cumulative effect my lord.
Hmm.
Now, by way of affidavit, my lord, the respondent says that it should be my lord, stoppage of one increment with cumulative effect. So punishment was awarded my lord, as my lord, stoppage of one increment for whole life. So the respondent has now modified this this punishment.
Hmm.
However, my lord, one case is pending. To my knowledge, due to pendency of this case, my lord, no charges has been filed, no FIR has been filed, my lord. My promotion has been held up, my lord, from 2009. So I have passed the my lord, pre-promotion cadet course for promotion to the post of ASI UB, my lord. That is assistant of Annam branch, my lord.
Any affidavits filed?
Yeah, but respondent number 9 has filed, right? Yes.
Who's
Nine.
respondent 9?
The superintendent of police, my lord, border, my lord.
Who's supposed to effect the promotion?
My lord, for the Assam police, my lord, is a IGP, my lord. Rule 37C.
Yes,
He has not filed an affidavit.
Lordship needs to file the affidavit on that count. An affidavit is required.
By whom?
Lordship, it is respondent number 7, Lordship.
So what the second,
There are two affidavits filed, one by border and one by CID.
One respondent number 9, Lordship. Another
Respondent 8.
now my lord, the petitioner is serving at border branch, my lord. And I am challenging the different proceeding of DP.
There are how many cases pending against you?
And now my lord, only
Two.
one case
No,
is,
no,
my lord.
it means
And
there were
other
two,
cases, my lord,
Lordship.
FR has been submitted, and some of the cases I have been acquitted by the trial court, my lord.
Hmm.
And after that, this judgment and the FR copy has been submitted to the department concerned, my lord. Even if, my lord, due to
There are
pendency of
Lordship.
one case of 2006, my lord, they have not given me promotion, my lord. Though
Total,
I have passed the pre-promotion career course, my lord, for promotion to the next career, my lord, my promotion has been held up, my lord.
total 5 cases were registered, Lordship. These are the very serious offense against the petitioner. Serious offenses.
I have done conduct records by parties, my lord. My lord, kindly see page, my lord, 9, my lord. Page 8, my lord. I have given the chart, my lord. Page 8 of my petition, my lord.
Yes.
I'm at so far second different proceeding concern, I have challenged the entire different
No,
proceeding.
how many, now what is the position
Now,
in respect of any DP against you
but DP number three over three
is pending?
now as per the affidavit they said that it is going to be disposed of
Yes.
three their affidavit respond number 9 in turn says 2 paragraph number 4 in paragraph number 4
Okay, then Mr. Goswami, you obtained the instructions about the status of the DP
Lordship,
stated to have been pending.
Lordship.
Mr. J.K. Goswami, heard learned counsel.
I want to first one thing kindly see the page 93
93.
yes sir. I have passed the pre-promotion period.
No, you have, but if there is a DP,
Yes, madam.
Yes.
then your cases will be kept under seal cover.
Yes.
So let us find out what is the status.
Yes.
Mr. S. Borthakur appears for the petitioner, Mr. J.K. Goswami, additional government advocate for the respondents. The petitioner is aggrieved by non-consideration of his case for promotion to the post of ASI within bracket UB with retrospective effect. As well as other pay benefits. Stop. In an affidavit filed by the SP Border Road,
Yes,
there is an averment that a DP, where is that?
para 4
Page 2, Lordship, in that affidavit. Lordship.
Para?
para 4
That DP number 03 of 03 was pending, is pending before the, is pending in the department initiated against the petitioner. Stop. Mr. Goswami prays for some time to obtain instructions with regard to the status of the said DP initiated against the petitioner. Let the matter be listed again after 3 weeks,
after 2 weeks.
2 weeks, enabling him to
Can I
obtain the
pray for
required
it?
instructions.
Can I pray for it?
A date, give a date after 2 weeks.
Lordship. 27. 27.
22.
22.
Yes.
May I please, my lord, by this petition, I have challenged the validity of order 7/6/2019 issued by the commandant, respondent number 5, dismissing the petition from the service from 17/6/2019, and the order dated 18/11/2019 passed by the Deputy Inspector General, respondent number 4, rejecting the appeal of the petitioner. First of all, my lord, I am taking to your notice. And this case was earlier listed on 8th of this month, my lord. And your lordship desired to have been where I was during the issuance of the notices.
During the,
Issuance of the notices by the respondent.
Huh.
For that particular purpose, my lord, first of all, I am taking to your notice at page 26, the imputed order dated 17/6. In this particular case, your lordship is
pleadings are complete. Pleadings are complete.
yes, they are fine.
Then we'll take it up for admission hearing at an appropriate, proper date.
My lord,
Some other date for an admission hearing. Give a date, please. List for admission hearing on so and so. Or we can admit it for hearing,
no, let it be admitted.
admission hearing, all right. List on 21st
21st of
September
Month.
for admission hearing.
Dean was supposed to be instructions, but
Lordship, I plead your lordship. Lordship, I am appearing on behalf of Senior Selling Council K Core Lordship. Lordship, in this matter, some more times may be given for further instruction, your lordship. Kindly, lordship, 2 weeks time may be given. Lordship.
perhaps lordship, my lord has first dealt with another similar petition, my lord, that is WPC 4407 of 23.
Mm.
In that case, my lord, though I have not the details with me, but it appears that it is a similar petition.
You get the order?
I'll
What is it that you're praying for?
I'm praying for, my lord, the
Pensionary benefit.
yes, pension benefit from old scheme. My lord. In line of the similar judgment, my lord, that is, I have annexed at page 38. Yes, my lord, page 38 of my petition. Annex 5. Operative portion, my lord, may be at page 48 and 49.
And what is at page 50?
This is, my lord, another petition filed by my colleagues that was disposed of with a direction to, my lord, file a representation for the grievance, similar grievance.
Hmm.
So that I am not a party to that representation. my lord.
No, well, that is an interim order. It is not disposed of.
Subsequently, it was disposed of, my lord,
Okay.
during the pendency of it. And I have heard, my lord, this person has again approached this honorable court.
You are employees under?
I was an employee under, my lord, DRDA Bongaigaon. Well, later on, I was absorbed in the Jilla Parishad in 2016. What they have done, my lord, since we were absorbed in 2016, that is why they have, my lord, adjusted us to avail the new pension scheme, my lord, rather than the old pension scheme. We were earlier recruited in 83, my lord, 1983,
Yes.
subsequently regularized
Regularized with effect from
from 1990.
90.
Yes, my lord.
Then why were you put in the new pension scheme?
No, because, my lord, the DRDA scheme, the whole DRDA organization was abolished, my lord, in 2016 by an office, by the government of Assam decision, my lord. So whole DRDAs were abolished and the employees were absorbed in Jilla Parishad in all the districts of Assam.
So they were absorbed under
Under Jilla Parishad.
Zilla Parikar.
Yes.
So now you are considered to be available, the new pension rule is applicable
Yes,
to you.
new pensions rule was applied, my lord. By the-
While you were under DRDA,
Yes.
you had your service book and everything open?
Exactly, my lord, yes.
Yes. What do you say, madam?
Lordship, as per instruction of my senior lordship, further more time be given, lordship, for instruction, lordship.
What instructions do you require? You have not filed your affidavits.
No, my lord,
No,
they have not
Lordship.
filed.
Mr. R. Chakraborty appears for the petitioner, MS so-and-so appears for the respondent. The respondents are permitted 3 weeks further time to file their response as the issues raised in the writ petition will require a proper response from the government, from the respondents. Matter be listed after 3 weeks.
Yes, date will be fixed.
Give it.
Obliged, Your Lordship.
Thank you, Lord.
Yes,
My senior is having some personal difficulty, Mr. P.K. Tiwari. Kindly adjourn the matter after with Lord.
you are making a mention on whose behalf?
P.K. Tiwari.
MS so-and-so learned counsel for the petitioner submits that the arguing counsel, Mr. P.K. Tiwari, has some personal difficulties today and seeks accommodation. Matter stands adjourned for a week. MS so-and-so appears for the respondent after 1 week.
Lordship, the matter has already been complied with, Lordship, and the petitioner has challenged the speaking order by WPC number 4828/2023. It was listed on 25/8/2023, wherein notice was issued. Lordship.
Yes. Have you seen the last order? This matter had come up earlier. We had considered for closing the matter. Subsequently, if you see the order of the writ court. Page number 10, 11. Page number 11, last paragraph.
Yes, in view of the and the director,
This was a consent order. Now you cannot pass an order cancelling, saying that they're both unqualified. This amounts to contempt.
Lordship, but they were not having the requisite.
You made a statement before the court. You said that one person who was there, that private respondent, he had joined somewhere else. The council, they directed that the department may be considered, directed to consider the case of the petitioner.
For subsequently, they had filed a review petition that was also dismissed.
Hmm?
They had filed a review petition also. That was also dismissed
Review petition
for the by against this order.
against this order.
But that was also dismissed.
Where is that order? Review petition. Why have you not enclosed it?
But that was during the finish of the contempt.
Now, you say this order is under challenge.
Yes, Lordship.
There's some writ petition filed.
Yes, Lordship.
Let this contempt matter be tagged along with.
Yes, yes. Yes, Lordship. That
Uh,
can-
It is submitted that by order dated 28/07/2023, the petitioner's case was rejected by the concerned department for on the ground that the candidates did not have the requisite qualification for being selected and appointed to the post of medical record officer. Stop. Learned counsel for the respondent submits that writ petition has been filed challenging this order, being WPC number
4828/2023.
4828 of
2023.
2023.
Lastly listed on 25/8/2023.
Stop. Under such circumstances, the contempt matter be tagged along with WPC so and so and will be listed together. List along with WPC number so and so.
Obliged, Lordship. Obliged.
May I please, your lordship? Okay, we are ready to do the case, my lord. My senior is on the way, my lord. Little bit of accommodation. My lord, we are ready to do the case, my lord. Mr. Gaur is coming, my lord. He is on the. phone.
No,
I
we
want-
have
I
granted
want
you
little bit of
sufficient time.
accommodation before your lord.
All right, after some time.
Look.
Subject to accommodation by the
Yeah.
council for the other side.
Look.
All right.
That I appear in item number 9. This is that NRL disciplinary proceedings matter.
Item 8, the
I
submissions are,
believe Mr. Mahonto had made submissions for the petitioner.
he has completed.
But perhaps he has completed because on the last occasion he was supposed to complete. He's not here. Huh? Yes, my junior says that he was supposed to conclude anyway. If your lordship permits, I can start today. Or Anita,
You can. Yes, you can.
Yes, Lordship, Mr. Nair is on legs in court 1, so he will come as soon as he is free. He is in the midst of a Pathan matter, Lordship, continuing for the last 3 days.
We are ready to carry on the matter. So you can begin your arguments.
Absolutely,
Yes,
why not? Because if Mr. Mahonto wants to add, he'll have a chance to reply after Mr. Nair finishes. But at the cost of repetition, if a lordship allows me, I will have to take your lordship through some of the initial facts. Now, your lordship recollect, there was a
Why don't
fact
you prepare a synopsis? Because your facts are more or less similar.
similar, my lord, but only
It is a question of an auction taken place in respect of 2 lots.
my lord.
According to the refinery, there were some burnt cables, some unused cables, and some perhaps usable cables. They were given in auction when they were not supposed to have been.
Given in auction was only
2
scrap
lots.
and bird.
That's
2
right.
lots. But what, according to the allegations, 2 coils of usable
That's right.
cables have also been given away.
Mm.
This is the allegation which has come. Now, my lord, certainly, my lord, because I don't think I can conclude today.
Why?
After my submissions, my
Why
lord,
you can't complete today?
my lord,
These are the only facts.
but a fact, but they are.
The question is the extent of judicial review in respect of,
Very limited we are before a very limited
that's right.
jurisdiction here. And my case is within that ambit only. I will not take your lordship's wider than
See,
that.
if you agree on a date, we can fix it so that at one sitting, the
Very
matters
well,
can be
Very well.
taken over, but you are never available, both councils.
Well, I am there only thing, unless they finish, I can't start. I mean, otherwise always.
You
Come
fix a date, both councils, you agree, and fix a date, take it from the court master, we'll take it up.
I will consult Mr. Nair and get.
Whatever you want to do, just take a date from the court master and
Very, very. On a-
matter will be listed and we'll conclude the hearing on that day.
And we shall also provide a synopsis for your lordship.
No, that is for your convenience, not for my convenience, because the facts are similar. There is nothing much about facts. It is only a question of whether during the subsequent subsequent materials being placed, whether it was correct for the inquiry officer to
Well,
go
not
through.
only the subsequent material, because my round, if I may just, I don't want to waste. your
No, we'll
lordship's
take it up.
valuable
We'll take it
time
up on
otherwise.
the next date.
Very
You
good.
give us a date and so that all councils are available, we conclude it.
We will inform your lordship's bench clerk.
Huh? Sorry,
We'll inform your lordship's bench clerk. Let my
Yes.
friend have a word with this man.
we'll take it up on second
Hearing
half
date,
of that particular day,
My lord,
either a Tuesday or a Thursday.
very well.
Keep it after 7.
Yeah, let me.
Matter stands adjourned to so and so
Okay.
or final hearing. Respondents are directed to keep the records
Yes.
available if required.
Deeply obliged.
Wait, please, Your Lordship. Your Lordship, my senior, Mr. P. Mohanto, is on legs on court number 1. Hence, he could not appear for.
We have already granted you adjournment before your submissions.
Much obliged.
No, 7. All item 7. Yes,
May it please the Lord. Lord, the case relates to, my lord, the removal of the petitioner from service here. And without any stipulation whether such service, my lord, could be a, my lord, disqualification for, my lord, future employment in the department here.
whether
Whether such removal, my lord, could be a, or could not be a, my lord, disqualification for future employment in the concerned department, my lord, that is the FCIL law. Now, my lord,
you are aggrieved with the quantum of punishment or the proceeding itself? Or both?
my lord, I am aggrieved by my lord, removal from service, and then, my lord, the forfeiture of gratuity and pension and all these benefits.
So
here.
quantum of punishment,
My lord, removal, yeah.
quantum of punishment,
Punishment.
not with the process, not with the DP itself.
No, my lord, I am against that, my lord, the proceeding itself, your lord. Because in this case, my lord, witnesses were there, my lord. Now, 8 witnesses altogether, your lordship will find from the judge memo. Out of this, my lord, only 2 were examined. And these 2 witnesses were also not, my lord, allowed to be cross-examined by the defense. And, my lord, the most, my lord, vital witnesses here, lord, their witnesses were withheld. Their statements were not recorded. And in that way, my lord, the punishment was given here, lord. Now, my lord, your, my lord, from Annexure 1, my lord, page 29, your lordship will find the charge memo here, lord. What is the charge, my lord? Now, the petitioner, my lord, he was, my lord, working as the assistant grade 2 in the FCI, my lord, Silchar Godown. He was asked to take, my lord, charge of this particular godown, your lordship, and he had taken the charge, your lord.
Now, while taking the charge, my lord, charge was taken on the basis of books, my lord, not by physical verifications of the, my lord, quantity of bags, wheat or rice, whatever it is, your lordship, or, my lord, weight, your lord. Now, the charge was that, your lordship will find page 31, your lord. Page 31, charge 1, my lord. A regional office team, after peripheral counting of stock in shed number 4, on the declaration of stock as on 23/7/2010, submitted by a state in charge, detected 300 bags of wheat excess, my lord, it was not less. They say that these bags are in excess in your, my lord, stack. So 320 bags in excess. The counting sheet was duly signed by Sofikur Chaudhary, that is the petitioner. Then charge number 2, my lord, a district committee from FTI district Silchar supervise 100% delivery operation movement of food stock during the month of September 2010. My lord. That is after, my lord, 23/7/2010, and detected excess 304 bags, your lord.
Yes.
Now, on verification of record, is revealed that Muhammad Safikur Raja Chaudhary taken proper care during receipt and issue of which check in his shed number sensor could not have happened. So, my lord, there should have been an award, my lord, if. Now, my lord, your lordship will find, my lord, the statements of, my lord, allegation most probably, my lord, paragraph 2nd, my lord. While Mr. Sofikur Chaudhary was functioning as a state in charge of Ramnagar regional office team, after peripheral counting of stock, as on so detected excess of 320 bags, your lordship. Subsequently, a district committee, district office Silchar supervised 100% delivery, and, my lord, they found, my lord, detected excess 304 bags. So bags are in excess, then what would have been, your lord? It is not less, my lord, than stack. That the allegation was not that the petitioner has, my lord, either told or had stolen this bag, your lordship. It is in excess, my lord. In this way, my lord, my submission would be, my lord, no pecuniary loss was caused to the department, your lord. Now, in these allegations also, your lordship will not find, my lord, that what is the quantity of bags handed over to the petitioner, your lord. The prosecution cannot say what is the quantity of bags that were handed over to the, my lord, petitioner. And, my lord, firstly, after saying this, they could say less or more, my lord. First, it is to be seen that how much quantity of the bags or, my lord, by weight was handed over to the present petitioner. That is not there, your lord. Now, what happens, my lord? I have submitted my written statement of defense, my lord. Now, what my lord, happens in FTI go down, your lordship, during transportation, your lordship, while loading and unloading into the truck. My lord, so many, my lord, these grains, your lordship, they are spilled, my lord, here and there. And then Ghani bags are also provided for collection of this spilled, my lord, grain. And, my lord, these were collected and put into the bags, my lord. In this way, my lord, it might have been, my lord, increased number of bags. So, number of bags, my lord, was found to be more, your lord. If I have stated, page 34, last 4 lines may kindly be seen, your lord. These steel grains of wheat, my lord, collected from different chamber stock has not been duly reflected in the stock ledger through oversight, for which the excess bags have been noted at the time of critical fitting, your lord. So that is the thing, your lord. Now, if fields get gain, my lord, these are collected and put into the bags, empty bags provided by the department, my lord, then these are put into these bags, and in that, whatever was the check, it go on increasing, your lord. And my lord, authorities also in their order, my lord, admitted these sorts of things, your lord. Now, my lord, page 35, therefore, my lord, I inform to your honor that I have no guilty of excess of wheat, so I request your honor access to extraordinary kindness. Now, my lord, enquiry report, your lordship may kindly see your enquiry report, your lordship will see page 38, your lordship. Altogether, my lord, 8 witnesses were there.
Hmm.
Now, out of these 8 witnesses, my lord, 2 witnesses were examined and rest were withheld. My now, what is the presumption, your lordship? Section 114, my lord, E of the Evidence Act. Is this other witnesses are, my lord, examined? Then, my lord, it might go against the, my lord, prosecution. So they were withheld, your lordship. And prior to that, my lord,
Where do you find it? From where do you find it?
My lord,
From where do you say that 6 witnesses were
no,
withheld?
my lord, I am coming, my lord. Here, your lordship will see there are, my lord, page 35, 8 witnesses, my.
Hmm.
And in the inspection report, your lordship will find, if your lordship proceed further, and then, my lord, only 2 witnesses, your lord. One is page 41, Nirmal Kumar Hajarika. He was examined, page 41, and
Page 41.
Kuchumesh Purkayastha,
Page 41.
page 41. Kushumesh Purkayastha and Nirmal Chandra Hajarika, out of these 2, my lord, 8 witnesses, they were examined, my lord, page 41, your lord.
What about the ones below?
One. Kushumesh Purkayastha. They did not witness, PC Datta did not appear because when supporting witnesses, now what they had
No,
stated,
no, there are other 3 witnesses.
now only we from this page 41,
Hmm.
we, my lord, find that 2 witnesses, my lord, were examined, and what they have stated, it has been, my lord, reflected in this page 41. What the other witnesses say, whether the other witnesses were examined, my lord, nothing has been said in this inquiry report. Now, my lord, I will be coming to that, your lordship. Now, I take your lordship, my lord, to page, my lord, page, my lord, 13. Now, my lord, your lordship may kindly see page 12, paragraph 14. That the petitioner begs to state that the petitioner was handed over
Page number?
page, my lord, page 12, paragraph 14, your lord. What happened, my lord, actually in this case? And authorities also ultimately say that this stocks were handed over on the basis of my lord book, and no physical verifications are done. Now, paragraph 14, my lord, page 12, that the petitioner begs to state that the petitioner was handed over the charges of 5,000 metric ton capacity godown. This is a, my lord, capacity of the godown with an approximate annual turnover of more than 65 lakh quintals of food grain Sarkar by the predecessor C. Manik Chandra Dev. So my predecessor, immediately I took over the, my lord, charge of this particular godown. Manik Chandra Dev, my lord, he was the, my lord, my predecessor. He was the in charge of the particular godown, your lordship. And, my lord, it says, my lord, without weighment of physical stock. It is admitted fact, your lord. Now, firstly, my lord, it is to be weight, my lord. X comes later on, your lord. What is the weight and what is the weight found during the verification? More or less, my lord. That should have been, but it was not done. And this Manik Chandra Dev, my lord, he is a, my lord, relevant witness, your lord. He ought to have been examined. by the prosecution, your lordship, for my lord finding out that how much quantity or how much of the bag he had handed over actually to the petitioner. But his statement, his my lord witnesses, his evidence, my lord, these were withheld, your lord.
You are not denying that there is a excess of,
Excess.
you are not,
My
you are
submission-
not denying that.
Excess, my lord. They have counted and they found excess. My
Your submission that,
excess.
your submission that that person who handed over the charge, the godown, was not examined,
Not exact.
is irrelevant in the face of your, in the face of not disputing that there are 320 excess baggage.
Now, my lord, I have stated predecessor Sri Manik Chandra Dev on temporary basis by area manager FCI filter dated so without weighment of physical stock. Thus, the petitioner was totally ignorant about the actual weight of the food grains, including wheat stock stored in the shed, until the entire wheat stock was weighed by the concerned physical verification official and made the godown shed empty. So the petitioner had to take charge on the basis of book balance reflected on the ledger book maintained by the petitioner. That is the case, your lord. Book balance, no weighment, nothing of the sort, your lordship. And this Manik, my lord, that there was not examined, your lord. Now, my lord, I take your lordship to my lord, page 16, your lord.
Hmm.
Now, in the godown, your lordship, I was assistant grade 2 and there was an assistant grade 1, my lord. Superman, he was actually in charge, your lord. My lord, paragraph 17, your lordship may kindly see paragraph 15.
Yes.
There's a petitioner begs to state that the same office by order number so and so, stated so and so, through who is the petitioner so and so assistant was directed to take over the charge of the state. This Sukumar Das, assistant grade 1, above the rank than the petitioner was also was posted at shed number 2. So Sukumar Dev, my lord, and actually in overall charge of the shed here. I was working under him. Now there was no disciplinary proceeding against Sukumar Dev, my lord. Sukumar Das, nor he is a witness, my lord, either against or my lord in favor of the prosecution. So there was a discrimination, your lordship will find that while I was number 2 in charge of the godown, the person who is number 1, he was not examined, not disciplinary proceeding, nothing was done, your lord. Now, my lord,
Yes.
let us go back, my lord, to the inquiry report, your lordship. Inquiry report, 8 witnesses, your lordship. Now, out of A, only 2 witnesses were examined that I could find, or at least 2 examined what they had stated, these were discussed. Other witnesses, if examined what they have stated, these were not discussed, your lord. Now, my lord, issue, my lord, page 39, issue register of shed number so and so under filter so and so, it is found in the register that 429 bag quintal was issued on 11/6/2010. This register was found maintained under supervision of the state manager so and so, and some calculations were given, your lord. How it became, my lord, excess 320, your lord. Now there are some, my lord, calculations. These are also not correct, my lord. I have calculated, my lord, everything. And what is the, my lord, total bags found during the inspection on 23/7/2000 in the godown on the inspection was not mentioned anywhere. What is the total bag and what is the excess bag? They only say excess 320, but what should be the total bag? Including this, my lord, 320 bags which were. Now, my lord, your lordship will find, my lord, that there was no theft, no criminal breach of trust, my lord, no malafide, nothing, your lordship. And your lordship will see, my lord, the evidence of the witnesses, page 41.
Yes.
They only say about this 320 bags in excess, nothing more, my. Now, in his statement, he disclosed, my lord, Nirmal Chandra Hajarika, manager D, in his statement, he disclosed that by the AGM letter dated so he, along with Anil Kumar Das and so were ordered to conduct physical verification of Ramgur. Accordingly, they conducted PB test at so he was a team leader out of them during their personal verification on 23/7. Instead, now they detected 3 packets of wheat excess against the balance stock declaration. Now, what is the balance? What is the declaration? They are not saying so. The said excess was detected at stack number so Muhammad Safir Raja Chaudhary was the shed in charge during the material period. To ascertain the reason of such shortage excess, a spot memo was served to the shed in charge of shed number 4 and the depot in charge. But no satisfactory reply could be received. I was not the depot in charge, my lord. I was the shed in charge of a particular shed, your lordship, shed number 4.
But non-maintenance of proper documents, proper books is considered to be a misconduct.
My lord, I am coming to that one. To ascertain the reason of such shortage excess, spot memo was served to the shed in charge of shed number 4 and the depot in charge. There was another depot in charge, my lord. So come on, sir. And now, my lord, he was, my lord, there was a discrimination, no disciplinary proceeding, nothing, my lord, against the commander. As they submitted their PB findings to the authority, on being shown, he admitted X5 to be the copy of the order given by the AGM Vigilance and Guwahati to conduct so exhibit 9 to be the copy of statement prepared by then on detection of excess 20 packets of wheat against declaration of 455 packets as on 23/7/2010 at check number 10. So exhibit 10 to be the copy of the spot memo they served to the state in charge. So replying to defense questionnaire, he stated and that in between 36/2010 to 23/7, there was no operation from stake number. They consulted the records of such master ledger stake census and etc. Now, what should be the actual stock, your lord, on 23/7/2000? My lord, that was not mentioned anywhere. And what is what he has stated in his cross-examination, my lord, it was also not, actually he was not cross-examined. If your lordship, if they have the record, my lord, it will reveal that he was not. Now, my lord, witnesses, my lord, Anil Chandra Das, Subhash, they were the members of PB so and they detected 320 packets of wheat excess against the declaration of 450 packets, stake number so where Safir Raja Chaudhary acted and so. Now, witnesses Umesh Purkaisko, your teacher stated that by an order so and so, my lord, they were detained, not detained, they detailed for so and so, my lord, typical verification of state number so and so Ramnagar, conducted 100% witment of stock of shed number so and so. During 100% witment, they detected 320 packets of wheat against the declaration. The finding of 100% PB, they submitted the area manager. Now, what is the bags he has received? And my lord, what was my lord issued? Nothing was mentioned, your lordship. Nothing, nobody has stated. It is a case of no evidence, your lordship. What is bag received and what are the bags issued, my lord? Nothing, your lordship will find. That much is the witness, my lord, evidence, and no cross-examination, your lord. Now, your lordship, my lord, next page 42, witnesses. Now, so
You
320.
were you afforded opportunity to cross-examine?
My lord, I tried to cross-examine, I was not given that chance. Yeah.
You were not given the chance or you did not cross-examine?
My lord.
You were not given the chance or you
No,
did
I
not
filed-
proceed?
After the punishment was imposed, my lord, I filed an appeal before the authority, my lord. That appeal was also not being disposed here
Appeal against?
against this imposition of penalty. Appeal line. That was not disposed. Now,
That was disposed of.
we did
That
not,
is not put to challenge.
in defense, all that.
Appellate order is not put to challenge.
They probably were not served.
He was, I filed an affidavit stating it.
No, my lord, I'll be coming to that, your lord. Now, my lord, defense, my lord, in the defense charge official denied the article charges against him, but in his defense he failed to put forward any convincing factor related to the storage access. They say, I am to read the evidence as to how this 320 bags access became your lord. I am to read evidence against myself. Article 20 violation. Now, being the custodian of the committee, the head in charge is the main person responsible for any storage or access occurred in the head. And if the same is not justified by reasonable ground, supporting document, convincing factor, that access of 320 packets amounting to malevolent intention of the concerned. A malevolent intention leads to what? 320 bags are excess. You sell this 320 bags, you will be gaining the department. It is not a case that leather bags, then what should have been has been found. But it is not the case. Excess bags is what. So department has actually gained. Now, my lord, some witnesses, your lordship will page 42, I have read, my lord, and your lordship will see finding. The facts and circumstances are well supported by the concerned record and statement of the witnesses. Article charge framed against Sufikur Raja framed by found to be proved. That much only, your lord. What is the, my lord, articles of charges? That 320 bags are. Whether, my lord, I have misappropriated anything out of the stock, whether there is a malevolent intention in my pet, where is any theft committed by me, my lord, whether there is any breach of trust, nothing has been mentioned. Only 320 bags were in excess, your lord. Now, my lord, a representation was filed, your lordship will find it post 44.
Okay. What, any judgments you want to refer?
My lord, only this is the finding, your lord. No finding. Finding, your lordship, inquiry officer at page 43. Only that. 320, there are no other finding regarding malevolent intention. What is the malevolent that, my lord, led to these 320 bags in excess? Nothing has been taken. Now, my lord, when I was furnished with the copy of the, my lord, inquiry report, I furnished, my lord, this my lord, representation before the authority. Now, your lordship will see, my lord, page 44. At the outset, my lord, para 2, your lordship will find.
Para
How
2
the,
of?
my lord,
Para 2 of?
page 44, para 2, my lord, how the inquiry proceeded, your lord. At the outset, my lord,
Para?
2, second paragraph. Second paragraph.
Of the petition.
Page
Pa-
44, my representation. My
Okay.
representation. At the outset, it is to be stated that on the departmental inquiry held against me under the referred memo and after examination of the witnesses called for to depose before the inquiry on different days and lastly on so and so. The inquiry officer here and there to be referred as your did not fix any date for submission of prosecution brief and no date was fixed for submission of defense brief by the charges. The EO also did not give the copies of the statements of witnesses that was recorded in different days. And ultimately, the copies of the statements, copies of prosecution were received by me defense on 23/6/2011 year.
This representation was disposed of.
Now, my lord, representation was filed, and my lord came the my lord impugned order, your lord.
Pursuant to the all right.
Impugned order, your lordship will see.
This is reply against the IO report. Representation against IO.
Now, my lord, order, your impugned order, your lordship will find. And my lord, your lordship may skip first few paragraphs and come to the paragraph, my lord, in the middle in response. 1, 2, 3, 4, 5, 6, 7, 8, paragraph 8, my lord, most probably in response. My lord, up to paragraph 7, my lord, up to paragraph 16, my lord, 1, 2, 3, 4, 5, 6, 7, up to paragraph 7 of this order, these are the state charges, my lord, articles of charges, allegations, and all that. Now, my lord, paragraph, I am referring to paragraph 8 in response. At the bottom side, your lordship will find
Page number.
page number 47 in response.
All right.
In response, Mr. Soifur Raja Chaudhary has admitted the written statement by representation. And so, in his submission, he pleaded that the only partition fact emerging from the inquiry report is that occurred an excess food grains at shed number so, and that whether or not there is any material to prove, even to suggest complicity of the charged official to the excess, that is what has not been proved in the inquiry. What is my part, what is my complicity, nothing has been stated, your lord. I was not a single person in this particular state. So many persons were working, and there was a head in charge, my lord, above me was also there, a senior person. Now, the IO, without any application of mine, has abruptly come to the conclusion that the charge are found to be proved. The IO did not show any reason in the report and instead made very mechanical approach to arrive at the conclusion. Now, this is a departmental inquiry, and therefore, to establish the guilt, the primary factor circumstances from which interference of guilt is drawn are duly proved by direct and documentary evidence. There is no missing link in the circumstantial evidence, and the inferred links are accurately based on legal presumption. It is the finding of the authority. The chain circumstances must exclude hypothesis of innocence to a reasonable mind in the instant case. Case ABC is not satisfied in the case is of no evidence and must and an acquittal of the. Now, whereas an opportunity of personal hearing has also been given to so before the undersigned during. Now, Mr. Chaudhary said that he had been holding the charge of head number so till completion of 100% ointment of wheat stock at so. Now, Mr. Chaudhary stated that there was no shortage excess of stock of wheat during the quarter so conducted by the district. We beat him against the declaration given. He replied that excess 320 weeks wheat is correct. The detection of 320 bags so quintal wheat by the district squad DO Silchar against the declaration is undoubtedly correct. S.R. Chaudhary, as he stated the reason for excess clearly elaborated in the reply nil against the memorandum. I have already explained the reasons. Now, I have gone through the charge sheet, reply there to PV report. PV report means physical verification report, IO report, your submission against IO report and relevant depot record. From the depot record, check register, Gani ledger, etc. The factum of excess of 320 bags of wheat detected by Arrow PV team on so and 100% wheat manure stock undertaken by a PV team from DO Shilchar as on 28 8 2010. Later on, your lord.
No, is there any particular portion of the order that you want to reflect to show that this was not considered by the inquiry officer
My
or
lord,
something else was contrary was stated?
Let me verify, your lord. Now, my lord, whatever.
We have gone through this
Now,
on the
whatever
earlier
has been
occasion.
stated in paragraph 3, my lord. So many calculations, my lord, so many this thing, and there is no evidence to that effect. My lord, evidence I have discussed here. Where from this, my lord, calculation came, my lord, I do not know. Then paragraph 4, my lord, no evidence. Nobody has stated all this. Now, grains are spilled, your lord. When filled, these are collected, and my lord, there will be excess of bags, my lord. Your lord, you may see paragraph 6.
Yes.
From Gani, the Gani bag ledger, it is evident the consumption of 320 pieces empty bags, empty Ganis for refiling of spillage grains of wheat is done after deduction of 320 bags. Wheat excess. So there was, my lord, excess 320 bags they had found, and finding is that, my lord, after that Gani bags again 320 Gani bags were filled up. What is this, your lord? What conclusion the authority like to, my lord, arrive with this? It is from this thing that there were the no stocks of jute so and so, as such there is no consumption of jute in picking back after empty Gani with spillage of grains when collected. So, my lord, actually there is no evidence to this regard, and these grains are spilled and these are later on collected, and, my lord, bags are made of these grains, filled with these grains. These are all admitted, your lord. Now, my lord, your lordship will now, therefore, page 49, your lord. Second paragraph. Now, therefore, the undersigned being the disciplinary authority in exercise of power conferred by Regulation 56, Appendix 2, read with Regulation 59.4, Regulation so and so. Muhammad Tafiqur Raja Chaudhary, the then state in charge, state number 4, Ramnagar, is hereby removed from the service of the corporation without immediate effect, and with further direction for forfeiture of his gratuity. My lord, how the gratuity is forfeited, my lord? Is it a prescribed penalty under their rule? Answer is no. And the suspension period of Muhammad Sanso is to be treated as done. Now, my lord, if your lordship goes to the discipline and approval regulation of this, my lord, FTI, your lord, FTI staff regulation of 1971.
Yes.
Now, my lord, removal may be there, your lordship. It is a, my lord, major penalty, your lord. Now, simply removal, my lord, cannot, will not do, your lordship, will not serve the purpose, your lord. So they have said, my lord, major penalties for 7, your lord. Removal from service, which shall not be a discovery.
Which rule?
My lord.
Which rule?
My lord, FTI staff regulation 1971, my lord, discipline and appeal regulation.
Page number 42.
My lord, that is correct, my lord. I have not included this thing. That is, my lord.
We have a copy here.
Oh,
This is section
uh,
54,
uh,
section 5,
54. 54 penalty.
54, yes.
Penalty. So minor penalties, my lord, I am not going into this. Minor penalties, there may be censure, withholding of promotion, a recovery of his pay, a whole or part of any pecuniary loss caused by. Now here, if these big excess are excess, my lord, and my lord, if the department has, my lord, sustained any pecuniary loss, then minor penalty recovery. Your lord. They did not go for that. And now, my lord, they straight come to major penalties, your lord. Major penalties, your lordship will find 6, 7, 8 most probably, your lordship. A removal from service which shall not be a disqualification for future employment under the corporation. Now, it is not dismissal. Next, your lordship will say dismissal from service which shall ordinarily be a disqualification for future employment under the corporation. So this removal, my lord, simplicity, my lord, is not a prescribed penalty. And if it is not a prescribed penalty, you cannot use the penalty. It is without restriction, my lord. I have a decision of the affected, my lord. I will be submitting to that. Now, where is, my lord, this punishment, forfeiture of gratuity? Where from they got it? It is not the prescribed penalty.
Yes.
So, my lord, no gratuity, no pension, no, my lord, arrear salaries, nothing of the sort. Man is a very old, my lord, and he is suffering. My lord, he is, my lord, he has now become a sick person lying in the pad, your lordship. And, my lord, what the penalty has been given, your lordship will find that is not a prescribed penalty. Removal, simpliciter, my lord, is not a penalty. Dismissal, my lord, they could have done dismissal, and with this dismissal,
Removal is at serial number 8.
8.
Why do you say it is not a prescribed penalty?
removal from service,
Uh.
which shall not be a disqualification for future employment under the code.
And what was imposed? What was the punishment imposed?
Post, my lord,
Removal, removed from service.
which shall not be a disqualification for future employment.
So
that
you are saying
option was not
the prescribed penalty is removal simpliciter, nothing more.
here, nothing more. That door was not kept open for me, my lord. It was also closed. In the meantime, my lord, the writ petition was filed, my lord, 2015, 12, and my lord, my lord, age of superannuation also came, but there is no question of superannuation over here. Ultimately, my lord, old man, he no gratuity, no pension, nothing, your lord. Gratuity he has earned in the department, your lord.
Yes.
It is not a resignation from service, a resignation for future, my lord, the past service and gratuity, a removal, my lord. So gratuity, this is his earned this thing, my lord, money, but that was not given, and there is no provision for forfeiture of gratuity in the prescription. So far as this regulation is concerned. Now, my lord, appellate authority, there is an appellate authority, and on 6/1/2012, my lord, the petitioner has filed my lord, appeal before the appellate authority, and your lordship will find that, my lord, at page 45, annex 44. 49, 50. Now, my information is that, my lord, that this appeal was not disposed of. Now, my learned friend said it was disposed of. Now, when it was disposed of, my lord, we do not know. And that is the thing here.
We have served a copy of the order to.
Now, my lord, your lordship will see their affidavit, what they say. What they say in their affidavit, your lordship. Even to आगे अच्छा से. Continue in the-
Paragraph, paragraph.
So, my lord, affidavit application filed by the respondent. Now, my lord, my lord, Nipendra Dev, he said he is the assistant general manager. He filed the affidavit, your lord.
You're referring to paragraph.
Now, my lord, my lord, paragraph 6.
6.
With regard to the statements made in paragraph 6 and 7, the writ petition deponent admits the same. So whatever I have, my lord, alleged in paragraph 6 and 7 of the writ petition, they admit it. Now, my lord, paragraph 9,
Where is that physical verification report? Is it available here?
my lord, I did not get here.
Is it available,
Now, my
Mr.
lord,
Uh,
when there is no evidence, my lord, direct evidence is coming, my lord. Now they had gone into circumstantial evidence, your lord. Paragraph 9.
Inspection report are here.
physical verification?
These are all, this is the
Physical verification.
inspection.
What
Right,
required,
my lord,
what
is-
necessitated the physical
What has
verification?
been said is in the reflected in the interim order. I'll take your lot to that. It is from the report, it is reflected in the order. The finding of the inspection report is there in the order. itself. I can give you lots of the original documents.
No, this physical verification, was it made available to the petitioner during the
His
inquiry?
signature is there. He is a party to the,
The time of the inquiry?
yes, at the time of, yes, all the documents are furnished to him. Documents were furnished to him.
All right.
It is part of the inquiry.
Yes.
Okay.
Now, my lord,
We have seen, we have gone through all that. So anything more you'd like to submit? Your basic case is that there is no evidence on the basis of which the conclusions were arrived at.
no, one thing, my respectful submission is that on the basis of the
Secondly,
evidence, my lord,
the
penalty,
allegation is excess baggage, not loss of baggages.
their affidavit, your lordship,
Hmm.
paragraph 13, they admitted something, your lordship might have
Paragraph
done.
13.
Paragraph 13 of their affidavit.
Hmm.
He said that they admit that Sukumar Das was the in charge, and if the petitioner wanted to examine Sukumar Das, I should file an application. They will not examine Sukumar Das. So what you are doing, this petitioner was working under you, and what you are doing, that they will not do. I am to prove my innocence, your lord. You prove your case first, then I will prove my innocence. And my lord, the deponent states that the main reason of excess of 320 vehicles is the petitioner during the receipt had declared receipt on so and so, whereas the issue is found to be so and so. There is no evidence of this thing, my lord. Then paragraph 15, 320 bags with 144 so and so quintal. Where is the evidence of this ointment and quintal? Witnesses came and they said there are 320 bags are excess, nothing more than that, Your Lord.
Hmm.
What was the total bag? And how these 320 where bags are excess? What to keep in the middle of the bag, number of bags?
Yes, all right.
Now they say, my lord, this affidavit, my lord, page 15, middle part, the deponent further states that no one stopped the petitioner from requesting the inquiry officer whom the petitioner decided to cross-examine. Now, my lord, if the witnesses were not cross-examined, then these are not the witness, my lord, evidence at all. Examination in chief, then cross-examination, these two, my lord, when combined, my lord, these are the evidence. Now he says that I should file an application for, it is the duty of the, my lord, inquiry officer to ask this man, do you like to cross-examine this person? Now, if he declines, that is one aspect. And if he agrees, that is another aspect. Now he says they admit that these witnesses were not cross-examined. Now, my lord, manner of imposing penalties, my lord, Article 311 of the Constitution, the basis of evidence, where these are all, my lord, examination in chief, no cross-examination. And with this, my lord, my lord, I submit some decision, shall I, your lord? My lord, 2012 5 SCG is prescribed penalty, man. Vijay Singh versus State of Uttar Pradesh, your lord. And my lord,
2012,
2012 5 SCC, my lord, 242,
2,
242, your lord. My lord, parties' names are Vijay Singh versus, my lord, the State of Uttar Pradesh. And then, my lord, against, my lord, this Food Corporation, my lord, on Hiradas versus Food Corporation of India cases, they are decided by my lord, Honorable Mr. Justice K. Sharma, reported in 2013 to GLT 1168.
2013.
2013 to GLT 1168, your lord.
Yeah.
Here, my lord, in this case, actually losses are, but this court, my lord, interfered. In my case, it is excess. That is the only difference. Other things are same, my lord. Then I have stated, my lord, for delinquent, although they are not, my lord, made delinquent officials, my in charge and my subordinate. But Supreme Court says, my lord, these four delinquents needs to be maintained. Parity, there should be parity. All of a sudden, a person cannot be singled out, but you should be punished. My lord, that is, my lord, 2013, the Supreme Court cases, my lord, 73. My lord, Rajendra Yadav for the state of my lord, Madhya Pradesh. And charges, my lord, charges should not be vague, your lord. 320 bags are excess. Then what leads? If it is excess, then what it leads to? There is nothing.
You are not challenging the charges.
That is not there in the charge. So in
You are
this-
not challenging the charges.
No, I am not challenging, my lord. But one decision is of the Supreme Court is there. The charges must be, my lord,
Specific.
charges should not be vague. Bank manager, my lord, they said he misappropriated, my lord, lakhs and crores of. Now Supreme Court says that no, your this thing charge sheet as a bag. So charge sheet, your lordship will find 2 or 3 lines.
That you're referring to some judgment?
My lord, that is my lord, 2011-14 SCC 14 SCC 379. Anil Gulekar versus Bilaspur, Raipur, Kshatriya Gramin Bank.
Yes.
My lord, have I given this, my lord, Guwahati High Court party's name, my lord? This, my lord, Hira Das versus Food Corporation of India.
Yes.
Guwahati, my lord, 2013 2 GLT 1166. Hira Das versus Food Corporation of India. And with this, my lord, I conclude.
Yes.
My lord, I will be handing over.
Not necessary. We can
How much?
take out copies. No problem. Yes.
My lord, first and foremost, my learned friend has said that the penalty is not prescribed. Lordship has seen the penalty of removal is prescribed.
Removal.
Removal is prescribed with the
Removal simpliciter.
removal, with the removal, with the consequence is given. It is always the removal means always will not, which will not, my lord, future employment will not there will develop.
No, no, your rules say otherwise.
Our rules say,
Without disqualification.
yes, yes.
Your
It is-
rules
it is
say
there.
it is
Our
removal
rules
from
say-
service which shall not be disqualified.
The consequence is also given. Removal, which is done. It is not necessary to say in the order the removal, this will not, it is consequence. It is obvious. It is good for him that there is no debarment. It is good for him. It is a consequence on it. The meaning is given. Removal, which means it will not be debarment of future employment. This is one thing. Secondly, my learned friend said that he was not allowed to cross-examine and all. But my lord, I'll take you to the relevant rule. Here, my lord, after the inquiry report was furnished to him, he submitted his reply. He has never raised this plea that he was not allowed to cross-examine, because the rule said he may cross-examine. He may, if he so likes, he may. Now, your lordship will come to
What
page.
is that rule? Rule?
Rule, my lord. Fifty-four is the rule, my lord. 54 is the relevant rule. I'll take you lot to the relevant part. 54, regulation 54. 54 and relevant, I'll take your lordship to that. Yes, by page 49. Lordship will come to page 49 of that.
Yes.
Sub-regulation 14 at the top. It says, on the date fixed for inquiry, oral and documentary evidence by which the article of charges are produced to prove shall be produced on behalf of the disciplinary authority. Witness shall be examined on behalf of the presenting officer and may be cross-examined on behalf of the, he may be. So he didn't ask, if he doesn't ask for it, it's not necessary. Now, my lord, in his reply to the inquiry report, he has never said, and if your lordship kindly come to page 47 of the writ petition. Page 47 down below. My lord, whereas my lord is seen, he was given, lordship got it last but one paragraph, page 47.
Yes.
What is his stand, my lord? What he says, whereas an opportunity of personal hearing has been given to so-and-so, AJ2, before the undersigned. During personal hearing, he has submitted. Mr. Chaudhary, AG2 depot has been holding charge of shed number 4, Ramnagar, February 2010 till completion of the 100% weighment of stock in the shed on up to 16/9/2010. Then he said, Mohammed Chaudhary stated that there was no shortage, excess of stock of wheat during the quarter PB conducted by district PB team against the declaration given by him on 30/6/2010. He replied that excess 320 bags is wheat is correct. Then he said the detection of 320 bags, that is 125.10 quintals wheat by the district squad DO against the declaration of 2810, the declaration given by him is undoubtedly correct. Then S.R. Chaudhary stated that the reason of excess clearly elaborated in his reply dated nil against the memorandum. This is a written statement. He said there was on the ground. I have already examined. Now, my lord, if your lordship kindly come to that page, my lord, what had happened, my lord? It is correct that there was no loss. There was no loss is correct. If your lordship, the reason is, my lord, how the modus operandi is. If your lordship comes the last para 7 of that page 48. Lordship got it.
One. Yes.
Para 7, I'll straightway come to I'll show to your lordship how the excess has happened. It is also observed from the record that during receipt of wheat consignment, so-and-so declared the received weight of 48.9 to 49.50 kg per bag, whereas the during issue it is found 49.77, 50.19 kg per bag. Hence, it is evident that S.R. Chaudhary abnormal transit loss, and as a result, Chaudhary could be able to gain 320 bags of wheat, allowing the corporation to suffer the loss. Next page, my lord. Next page. It is true that there is no loss. Considering all facts and circumstances, undersigned is the opinion that findings, observations with the inquiry officer confirm the standard of proof that is required to establish the guilt of the charge of Mr. Radha Chaudhary, the then shed in charge, shed number 4, Ramnagar. Hence, it is established that Mohammed Raja Chaudhary procured 320 bags of wheat by adopting malpractices with his ulterior motive and personal gain, and managed to hide out the facts during the quarter ending PV as on 36/10, but he failed to fulfill his object. He just got it done, but he failed to take it, sell it, or whatever. That is why this is not done. Lordship, the misconduct to which is relevant for him, my lord, is, my lord, will come to page 27. Because I don't want to go in detail, your lordship, as my learned friend has gone in detail. Misconduct, my lord, is what is relevant for him is 32, page 27. Lordship got it. 32 capital A. 1. This is without prejudice to so-and-so. Theft, fraud, or dishonesty in connection with the business and property of corporation, of the property of another person within the premises of the corporation. This is 1. Dishonesty in connection with the business.
What is dishonesty?
Lacking bona fide, it is not, what is done is not honesty, my lord. This is the one. Then he was charged with for 32A5, acting in a manner, next page, acting in a manner prejudicial to the interest of the. This is obviously it is not something which is done, my lord,
Yes.
for the interest of the corporation. And 9, and he was charged with misconduct number 9, subclause 9. Neglect of duty is obvious. There is the neglect of duty, lordship is in the beginning indicated. Now, my lord, what had happened, my lord, it is like this. Page, I'll tell your lordship what had happened from page 48. My lord, he was in charge of shed, particular shed, from February 2010 to September 2010. Then in May 2010, stock of that particular shed was 1384 bags of wheat. That was in May 2010. And June 2010, out of that stock, 929 bags were issued. As a result, the stocks as per book balance should be 455 bags. From July to till the date of PV, there was no operation. So stock as on June 2010 till the date of inspection, as per book, he has also declared that 455 bags. But actually it was found, my lord, it was found 1384, it is 326 bags access. So how the access has my lord, occurred is, as I've read it before, lordship. This is the finding of the authority. It is a fact, my lord, that there was no loss from the, because along with him, another employee was charge sheeted, who was found in his depot, in his godown, I mean, in his shed, which was found less, shortage, simultaneous. So this is modus operandi. So I'm not, because that is the petition is pending. There is a different petition pending. You know? He has challenged that because in his case it was found shortage. Here industrial access, same shed, same at the same PV. So this is what happens in the Gordon Malone. Now, as I said, may not true that there was no loss, and so far as the submission made by learned friend that this gratuity recovery, my lord, I also find, my lord, I'll leave it to your lordship, because if from the gratuity is to be something is to be required, then we will have to have a loss. This is what our rule, even the Gratuity Act also says. We'll have to have a loss. This is my submission, my lord. I do not consider your lordship, I leave it to your lordship, because I personally I feel this part of the order, not in consonance with the rule. I must admit to this, because if you forfeit something for the gratuity, the authority must have a loss, because gratuity is his right under the Payment of Gratuity Act, as well as our rules also. My lord, for
Yes.
that, my lord, I'll have to leave it to lordship. I'll not. And quantum, my lord, admittedly, he did not work, my lord, to the interest of the corporation, not bona fide. And so far as the quantum, my lord, the decisions of the Supreme Court are concerned. It's a related parameter. 2013. Yes, that is true. My lord, 2013, 10 SCC 106.
Yes.
I'll straight away, because I'll cut short, because I do not like to go on other sections.
Paragraph.
I read para 7 and 8. Lordship got it.
Yes.
Para 7, when the charge is proved, as happened in the instant case, it is the disciplinary authority with whom lies the discretion to decide as to what kind of punishment to be imposed. Of course, this discretion has to be examined objectively, keeping in mind the nature and gravity of the charge. The disciplinary authority is to decide a particular penalty specified in the relevant rule. A host of factors go into decision making while exercising such a discretion, which include, apart from the nature of the gravity of misconduct, past conduct, nature of duties assigned to the delinquent, responsibility of the duties assigned to the delinquent, previous penalty, if any, and the discipline required to be maintained in the department or establishment where he worked, as well as the extenuating circumstances, if any, exist. Next, para 8. The order of appellate authority, while having a look at the case would obviously examine as to whether the punishment imposed by the disciplinary authority is reasonable or not. If the appellate authority is of the opinion that the case warrants lesser penalty, it can reduce the penalty so imposed by the disciplinary authority. Such a power which vests the appellate authority departmentally is ordinarily not available to the court or a tribunal. The court, while undertaking a judicial review of the matter, is not supposed to substitute its own opinion on reappraisal of facts. The other decision, in exercise of power of judicial review, however, the court can interfere with the punishment imposed when it is found to be totally irrational or is outrageous in defiance of logic. This limited scope of judicial is permissible, and inference is available only when the punishment is shockingly disproportionate, suggesting lack of good faith. Otherwise, merely because the opinion of the court lesser punishment would have been more appropriate cannot be a ground to interfere with the discretion. So, my lord, here the para 7 said the disciplinary authority look into his position, because he is the shed in charge of that particular shed. He is to look into each and every transaction which is provided in our rules also. My lord, it says, if your lordship it says, my lord, he will look into every transaction, my lord, meticulously. This is also there. My lord, he is a shed in charge, he is to look into all transactions. Now, my lord, so far as the quantum, as I said, my lord, if lordship kindly take our additional affidavit file to bring to your lordship the authority, the order of the appellate authority, filed on 29/4/2015.
Affidavit of
That is, we filed a supplementary affidavit filed by us to put on record, because even before the filing of the writ petition, this appellate order was passed. Lordship got it, the supplement.
supplementary, yes.
Yes, my lord, I have annexed it, my lord, at annexure A, page 4. This is the appellate authority. Of course, appellate authority did not interfere. It is only confirmed the order. Now, my lord, if your lordship finds that the appellate authority ought to have looked into the quantum in terms of the decision of that decision, my lord, objectively, my lord may ask the appellate authority to have a revisit, my lord, and relook at the order of penalty. That, my lord, your lordship can. But so far as the, my lord, misconduct, my lordship may not like to interfere. This is my submission before lordship, because admittedly, my lord, shortage or access, it has resulted because of his conduct. True, we have not incurred any loss, but if this would not have been detected, my lord, we would definitely have incurred loss.
Okay.
Timely inspection led to recovery of this, my lord. The disciplinary authority has also said this in his order in detail. So these are my humble
Is there
submissions.
any regulation which describes the role or responsibilities
I
of
have given, my lord, I have given a last occasion, lordship will have a,
this one?
no, not this. There should be job description and all. There are some,
Job description.
I think your lordship will have them. There are,
Duties and
I had one copy, my lord, that
Yes,
lordship
yes,
will
dut-
look into it, my lord,
duties
then-
and responsibilities.
lordship. It is there, my lord. So, my lord, my submission is that in view of these materials on record, lordship may not like to interfere the order of penalty or order, my lord, holding him to be guilty. But so far as penalty is concerned, my lord, I leave it to your lordship. But my submission of your lordship will not interfere even with the quantum of penalty. Rest, I will leave it to you.
Yes. All right. Heard. Council's reserve. Okay.
Lovely.
Thank you.
Deeply.
Lordship, I pray for timing of
Time being.
Dr. Sharaf legs in court number 12.
At 2. Second,
Lordship, it too, I have one parted matter in court number 9. Lordship.
they're getting difficult to carry on. Like
Otherwise, senior counsel has already completed his argument. I was supposed to give some.
he wants to be present while you reply, perhaps. The
Okay.
reason. So give us the date. 8. Sorry, 7.
7 is reopening the lordship. I'm not.
Hmm?
Maybe 6 months.
7. You get a date.
Much.
7th September. Yes, Mr. Nayak.
In this matter, on last day, your lordship asked me to obtain some instruction, lordship. I have already communicated. They're asking for some more time, lordship. 1 week time will be sufficient.
All right. Let it be on 11th.
Lordship.
Agor matter. Let it be on 11th.
Lordship. Lordship, be it on 12. Lordship.
1 day.
All right. Good. Complete. All right. Right. As well as government.
This case actually is covered by earlier division bench judgment, my lord. All other employees, my lord, they were given the benefit of regular. And person below to me were also regular. I was only left off, my lord. So that judgment, my lord, page 47. Last occasion also, both the council were present, my lord, and that submission was raised.
Oil India Council.
So the page 47 is the redefined judgment.
47.
Page 47. Annexure 5. So
Yes.
that page 47, if your lordship will see, there was an employment notification. That subject matter of that, my lord, notification is already been decided by the division bench. And
What was the finding?
finding, my lord, your lordship will see page 52 onwards, my lord. May I read page 52, paragraph 18?
Hmm.
As we have already arrived at a conclusion that there does not exist any intelligible difference here between the candidates selected and appointed under the same selection, there cannot be a differential treatment as regards their regularization and confirmation. And further, such differential treatment cannot be sustained by stating that this was done on the basis of order of merit of the selection. Even such stand is unacceptable inasmuch as persons below in the select list have been regularized and confirmed, whereas those above in the order of merit are yet to be regularized confirmed. No other reason has been disclosed by the respondent authorities for meeting such differential treatment. In the circumstances, the only conclusion that can be arrived at is that there are discrimination and biasness in affecting the regularization confirmation, and the procedure adopted by respondent authorities violates Article 14 of the Constitution of India. Para 19. In the circumstances, we have considered view that ends of justice will be met if the respondent authorities in the IOC have to regularize the service of the appellant, and that such regularization along with benefits accrued thereof be given with effect on the same date as to when the last of the 11 candidates was so confirmed or regularized. Accordingly, the respondent authorities are directed to regularize the service of the appellant from the date when the last of the 11 candidates were confirmed or regularized, and all consequential benefits of being regularized be provided to them from the said date. Now, your lordship will see the notification, common notification mentioned in this judgment, my lord. Your lordship will kindly see page 48, paragraph 4, my paragraph 4 of the judgment, my lord, page 48.
Hmm.
The appellant made a claim that out of the candidates who were appointed pursuant to the recommendation of the selection committee in his meeting of 30-10-1995 and 31-10-1995, 11 of the candidates have been confirmed in their services, where the appellants were also appointed under similar circumstances and as per the same selection procedure have not been confirmed. Consequently, the appellants made a claim that they also be regularized confirmed in the same manner as has been done in case of 11 other similarly situated candidates. Now, para 5, in furtherance of their claim for being regularized, several representations were made from time to time, and in consideration thereof, various communications were made. In one of such communications dated 20/1999 of the department member, it is stated that although the temporary employees do not get all the benefits
applicable to the permanent employees, but upon their request being examined, the authorities took the view that as the appellant are working against the permanent vacancy, this is the word, madam, we are also working for. Therefore, the benefit of casual leave and medical facility be given to them. Another communication from the chief HR manager dated 28/3/2006 indicates that the question of regulation of the service of the temporary employees have been taken up with the competent authority in the headquarters, and that the same has been pursued from time to time. The said two communication give an indication that the claim of the appellant for being regularized was under consideration of the respondent authorities in the respondent IOC AOD. Now, para 7, my lord. In the course of hearing of the writ petition, the appellant relied on the judgment of Supreme Court rendered in people so and so to contend that under Article 23 of the Constitution of India, in the event an employee was paid less than the minimum wages, it would amount to forced labor. Reliance has also been placed on the judgment of the Supreme Court rendered in the case of State of Punjab and others versus Jagdeep Singh, and by referring to paragraph 55, it was contended that an employee engaged for the same work cannot be paid less than another employee, and it is a duty and responsibility of welfare state to ensure payment of appropriate wages. Accordingly, the appellant raised a contention they are entitled to be regularized in service and be paid the same salary and allowance as payable to a regular employee. On the other hand, next paragraph, it was contended on behalf of the respondent IOC that the employment notification of 7/4/1995, that is a common notification, where I am also being considered, indicated that the recruitment would be in respect of six temporary vacancies, and therefore the appellant having been appointed pursuant to the said notification, they cannot claim the right of being regularized. In appreciation thereof, the learned singular so I will read my lord para 10. Being aggrieved by the non-consideration of the claim for direction to be regularized in service, the present appeal has been preferred. It is taken note that in paragraph 13 of the writ petition, appointment has been made that 11 candidates appointed along with the appellant pursuant to the same selection process have been confirmed by the respondent authority. In reply thereof, the respondent IOC AOD had not denied such appointment, and on the other hand, in paragraph 19 had admitted that in fact the 11 candidates who were appointed pursuant to the same selection process as that of the appellant have been confirmed in their service. Respondent authorities in their affidavit seeks to justify the same by taking a stand that 11 candidates were regularized as they were above the appellant in order of merit in the select list, pursuant to which they were appointed. The list of the 11 candidates who were so regularized find place at 56 of the memo appeal, which also contains the name of the applicant by showing that they are not confirmed as here. Para 11. From the employment notification dated 7/4/1995, it is discernible that there is no such indication that only some of the candidates who are to be appointed pursuant to the process would be regularized in the due course as per their order of merit, and that the remaining selected and appointed candidates would not be so regularized. The employment notification uniformly provides that the appointment to be made would be against temporary vacancy, and although it refers to 6 number of vacancies, but it is an admitted position that 9 unreserved candidates and 8 reserve candidates were recommended and appointed. I also belong to 9 unreserved category. It has also admitted position that out of the 7, 11 had been confirmed in service. In view of such factual situation, a provision in the employment notification that the recruitment would be for 6 temporary vacancies had lost its relevance. And the same itself also cannot be a reason to regularize 11 of the appointed candidates while not regularizing the others. In the absence of any such provision in the employment notification or in the minutes of the selection, that some of the selected candidates would be regularized while others would be not. The procedure adopted by the respondent authorities to subsequently regularize some of the selected and appointed candidates. While
Yes. While
were led by Senior MK Sudhir, sir. Lotip has already heard his matter. Lotip has picked the matter at 2 p.m. He is on like in court number 10.
all right, is it covered or not?
Lotip, last time he has apprised the honorable court that regarding the judgment and rem and judgment and person, this is not covered case, and regarding the delay because he is sleeping in the matter for 22 years. Lotip. His initial selection in the year for 1997. Thereafter, from 22 years, he has not raised any objection, Lordship. And subsequently, there is temporary engagement. And he has accepted the temporary engagement, Lordship. So,
You want it at 2 p.m. 2 p.m.
he is only in court number 10.
You are seeking the matter to be taken up at 2 p.m.
Or Lordship Thursday. Lordship has already heard his petition.
Only thing is, my lord, very
Lordship
limited
has
point
already
is,
heard his petition.
in 2006, they themselves has given a letter considering our regularity.
Very well, we'll take it up on Thursday. Let it be on Thursday. As agreed to by learned counsel for the parties. Yes.
Obliged.
This matter may be closed because, my lord, the petition has given her voluntary retirement way back on 2020. My lord, I have the
She's the
instruction.
one, but her claims, will it become?
Claim, my lord, it was incumbent on the petitioner side
To pursue?
Yes, my lord. She did not. So therefore, even the advocate also possibly lost the interest. It was their duty to inform the honorable court the matter has become infracted.
Heard Mr. H. Dr. Learned Senior Counsel for the respondent bank. None appears for the petitioner on call. Mr. Dr. has placed before the court communication dated 2011-2020, whereby the application for voluntary retirement sought for by the petitioner has been accepted, and the petitioner has been issued the release order pursuant to the said communication. It is submitted that in view of the petitioner's application for voluntary retirement having been accepted, no further cause survives in the writ petition. Stop. It is also submitted that the petitioner has not pursued the matter pursuant to her release, pursuant to the acceptance of her application for voluntary retirement. Considering the above and taking the submissions made by the learned senior counsel on record, the writ petition stands closed as not pressed. Interim order, if any, stands vacated.
Much okay.
But it's for removal from service. Removal from service. My main ground is that my lord, clarity of panel. Altogether, we are 7 persons. All of them were reinstated or given compulsory retirement. I have given the same punishment. My lord, herein, my lord, petitioner while serving as operator in computer branch, Government of Assam has sanctioned an amount of rupees 2 crore 29,67,728 for disbursement of arrears salary.
Flash करो.
My lord, for disbursement of arrears salary, dearness allowed to the force personnel of 8th Assam Battalion. my lord.
Yes.
And accordingly, my lord, petitioner along with 7 others were directed to prepare the pending DA arrear bill with effect from 1198 to 31/5/21, 2001 and 17/2002 to 31/5/2005.
Where is it? Where is that order? Impugned order.
Impugn order is there at page, my lord. My lord, page 119.
119.
119.
No, where is the show cause?
My lord.
Charges? Where are your charges?
Lordship, at page 31. my lord.
Yeah.
Okay.
What is your name?
My lord, Vijit Kumar Roy.
Bijit. Then,
Now, thing is that, my lord, except me, all the other persons, altogether there are 8 persons, all the other persons are already reinstated in service, or some persons have been given compulsory retirement. If Lordship may kindly come to page 85.
yes,
ABSI Mohizuddin Mondal.
this is the appeal.
Yes,
Eight-
appellate
85,
authority given the
85,
85.
85 is the appeal order.
Appellate order.
Where is the inquiry report?
Inquiry report is Lordship. And Annexure 6, man, page 41.
Yes,
Initially, my lord, inquiry, after given the inquiry report, I was not given the opportunity to submit my representation, and that's why the first round of litigation, Honorable High Court given a direction to allow him to submit his representation. Now, thing is that, my lord, all other persons, if Lordship may kindly come to page 85, my lord, appellate authority has given them,
this inquiry report is only in respect of you or all.
no, only
Separate inquiry was held. Separate inquiry was held.
it is in respect of me only.
Separate DP was being held for you. Separate DP was being held in regard to which.
You are the kingpin.
No, my lord. Other senior persons are also there, my lord.
No, come to page 60. This is the finding.
Yes, my lord. It is written like that. He master role to meet the appropriate government.
But that is the finding of the inquiry.
Otherwise, my lord, all the other persons already reinstated or some persons were given compulsory retirement, except me. This is the difference of the severity of penalty. If Lordship may kindly come to page 85. my lord. That is the when ABSI Mohizuddin Mondal. He was
Yes.
reinstated in service. my lord.
This
And
is
given an order of stoppage of
this
two
is this is for somebody else.
He was given a punishment of order stoppage of 2 annual increments without cumulative effect.
Where is the inquiry report for this person?
Other persons
To inquiry for the district mark. That inquiry report that all these efforts we have received in the office in regard to other persons. Visit my lord to
Yes. No, receiving in the office is okay, but his case is that there's he is praying for parity of punishment.
comparing his case with other case.
Yes.
Then lordship, we have to bring the other records also. We have to compare the inquiry reports and
You
everything.
compare.
lordship. Because today I have from that lordship, it's a big carton lordship. From that lordship, I have selected the only Vijay Kumar Roy thing because only his matter has been listed today, and I have brought now lordship.
Are the other persons also before
Yes, lordship, we have received, we have the records in regard.
Are the other persons have also filed cases before the court?
Yes, my lord. One person is there, my lord. That is, I have filed with my affidavit in reply. That is, my lord. Uchut Polita.
Hmm?
Uchut Polita, page 151.
Who is the first?
This case was disposed of.
What was the direction?
My lord, punishment is modified to compulsory.
Hmm?
Compulsory. He was given the punishment of compulsory retirement with full pension. Direction was here. Page 170.
Hmm. What was the original punishment given?
Original punishment, my lord, is same, my lord, removal from service.
What is your name?
Vijit Kumar.
Now, these are separate issues. This is not one act. The persons whose cases you are relying on relates to the release of DA and all that, but in a different,
I had given the comparative statement, my lord. If lordship may kindly come to 140. Okay. Oh.
one,
141,
141.
I given the chart, my lord.
Hmm.
Initially, Mr. Serial number 1 Moizuddin Mondal,
Hmm.
he was removed from service by order dated 31/12/2015. Appellate authority reinstated in service. Thereafter, my lord, Ashok Kumar Kora, Havildar clerk.
No,
He
these
was-
are pertaining to the same episode.
Yes.
So how many persons were involved?
Altogether 8
Eight.
8
So there are six, you are seven.
And that is the restitution order is then. It is the 7%. My lord, that is. Uchuk Kolita. His name is not here in that.
Hmm.
He is the 7th.
What was the direction issued by the court?
My lord, it's page 174, paragraph 11.
These amounts have been recovered.
Yes,
The
yes,
amounts have been recovered.
recovered.
Yes, what do you say, Mr.?
Lordship, as per this record, apart from the this thing, Lordship, appeals and orders in appeals and orders, Lordship, and the preliminary order, the statement of Ashut Kumar Kolita is stated here, the deposition of Kolita. And Lordship, there is another one, admission, Lordship, admission of offense, which is signed by all the parties, is Lordship, is included in the report, Lordship. It is Lordship basically.
No, your appellate authority has modified the
Lordship,
punishments
Lordship,
in respect of the other persons.
Lordship.
Two persons, it was not done. One has been done by the court, and this is the last person.
Lordship.
So, if these are people involved in the same transaction pertaining, arising,
It's same incident, Lordship.
Same
That is
incident.
same incident.
then why different stands for different persons? That is the core issue.
Basically, their person, Vijay Kumar, the person is that order has been come from heaven. Now he is the person responsible in disbursing the amount to the next of kin of his lordship. So that gravity of offense, lordship.
What was the punishment? Removal.
Everyone was given the same punishment.
Although criminal conspiracy is there, lordship. That we cannot do. Yeah,
He's not seeking interference with with the proceedings.
no.
With the
He is
finding.
only that only instead of dismissal of service, he can be. That part I leave it to lordship because appellate orders are lordship already have.
No, you are not supposed to leave it to us. You are supposed to address us and tell us.
Then lordship make kindly see the appellate order, lordship.
Hmm. Where is that appellate order?
I am reading from, lordship. Is lordship willing to see the record, lordship, that we have obtained, lordship? Can I provide, lordship? Because everything is here, lordship.
We'll go if required.
Appellate order is at 125.
125. What is that 119?
119 is the my lord removal order.
Why did you file the earlier case?
My lord, after given the inquiry report, I was not given the opportunity to submit a written reply.
But subsequently,
Punishment was given.
he has filed his reply against the Sokos, lordship.
Show cause pursuant to inquiry.
First show cause and no. after inquiry, my lord, after given the direction perspective honorable court, I have given the reply against the inquiry. Against the
Yes,
inquiry.
yes.
Against the show cause or the inquiry?
No, against the inquiry,
Against the inquiry. That is prior to imposition of punishment.
Lord.
Yes, appellate order, yes,
120.
yes.
Okay, peruse the appeal petition so and so prepared by Vijit Kumar Ray, Udaipuri against the order of his removal from service passed by the commandant. However, Fridays memo number so and so, departmental proceeding file number so and so, drawn up against Vijit Kumar Roy of 8 AP Battalion, some police battalion, Udaipuri, which was disposed of by removing the appellant from service, is made available to examine the appeal case. I have studied the proceeding of DP Sensor Udaipuri, which has been drawn up against appellant Vijit Kumar Roy. I have also studied the appeal of the appellant and the grounds on which he has requested for setting aside the order of the discipline authority. 18 AP Battalion, Udaipuri, Bamagor, removed the appellant from service. From the available records, I have found that the discipline authority has followed all necessary procedure, rules and formalities while bringing the departmental proceeding to a logical conclusion. The grounds which the appellant has described to contest the findings of the departmental proceeding leading to his removal from service are not found to be sufficient for me as an appellant authority to interfere with the orders passed by the disciplinary authority. I therefore, as the appellant authority, would not like to interfere with the order passed by the disciplinary authority, that is the commandant so and so. The order of the disciplinary authority is hereby upheld accordingly. After that, Lordship, this order has been passed after going basically to the evidence part, Lordship, that is the deposition of Asyut Kolita, Lordship. Perhaps it is not available in the court record, it is available here. Lordship. May I just read out the deposition of Asyut Kolita, Lordship. He is found a witness, Lordship. ওপৰত উল্লেখ কৰা নাম আৰু ঠিকনা মোৰ হয় আৰু সত্য, সেয়ে অসম আৰক্ষী বাহিনীৰ অধিনায়কৰ কাৰ্যালয়ত চনৰ মাৰ্চ মাহৰ পৰা OMG হিচাপে আৰু চনৰ পৰা বাহিনীৰ দুটি হিচাপে কৰ্মৰত হৈ আছিলো। যোৱা মাৰ্চ মাহ চৰকাৰে দুটা কিস্তিত ক্ৰমে তাৰিখ কিমান চনৰ আৰু 2009 লৈ আৰু 2002 পৰা 2005 লৈ কি হয়তো বকেয়া সময়সীমা বাঞ্চনৰ ধন মুকলি কৰি দিলে। একাউণ্ট ব্ৰাঞ্চৰ পৰা সৰহীয়া বাঞ্চনৰ পেৰল চাই চিতি দিয়াৰ পিছত কম্পিউটাৰ বিভাগৰ হাৰ্ড কপি আৰু ছফ্ট কপি চূড়ান্ত বিল প্ৰস্তুতি কৰি বলৈ দিছিল। সেয়ে সময়ত কম্পিউটাৰ বিভাগৰ কম্পিউটাৰ IT হিচাপে আৰক্ষী বিজিত কুমাৰ ৰয়, কম্পিউটাৰ অপাৰেটৰ গোপাল চন্দ্ৰ দাস আৰু কম্পিউটাৰ অপাৰেটৰ আৰক্ষী বিজিত মণ্ডল আদিয়ে কাম কৰিছিল। যে সময়ে মোৰ লগতে হবিলদাৰ অশোক বৰা সহায়ক হিচাপে কম্পিউটাৰ বিভাগত মৰগীয়া ব্ৰাঞ্চৰ বিল প্ৰস্তুতি কৰাত সহায় কৰিছিল। মৰগীয়া ব্ৰাঞ্চৰ বিল চোৱা চিতা কৰাৰ বাবে মুখ্যত ৰসৰাজ ভট্টাচাৰ্যী আৰু চিনিয়ৰ একাউণ্টেণ্ট সুৰেশ ৰয় দায়িত্ব আছিল। মৰগীয়া ব্ৰাঞ্চনৰ বিল হাৰ্ড কপিত যোৱা।
You give us the findings of the inquiry report.
Lordship. Finding in the issues, Lordship.
Mhm.
Finding in the issues, reasoning in the
Or at least give us the orders of the disciplinary authority
Lordship.
insofar as all the other persons are concerned.
Lordship.
It's available there.
It is available, Lordship. It is like, I'll make available, Lordship, before the court.
The orders passed by the disciplinary authority on the
Yes, because the facts will be there, Lordship.
inquiry report.
Yes.
Thereafter, if we require, we'll go through.
Yes.
Just want to have a cursory look as to how the evidence has been taken against.
Lordship,
the
that's
others.
fine.
When can you get it?
It is already available in the office, Lordship. Lordship fixes the matter. Not day after tomorrow, Lordship. Day after tomorrow is Lordship. That's some difficulty.
Matter be posted again on 12 September. 12.
Lordship, can it be on 14th of September, Lordship?
14.
So the September.
14 September.
Whether they will submit all these by way of affidavit or
No. That will be, it will take time then.
because we have to.
We already have the.
Let him
record.
produce, let us first. Let the court have a look. If required, we'll hand it over to you. You can have a look. List again on, so now what remains? We will close this matter, giving you liberty to challenge it.
Lordship, but that order is not there, Lordship, on record,
Which order?
by which it was rejected.
Did you not,
Even then I may be a
did you not furnish a copy?
I have filed an affidavit in this regard.
Affidavit?
Yes, sir. It is in near the-
Oh, yes, 1st of August,
Yes.
yes. Does it not, it doesn't include the order?
That order is not there otherwise,
Then why don't you give him a copy?
but then I will provide him. You may close the matter, my lord. In the meantime, I will provide to my friend. Anobike.
Where, what is the date of the order? Nothing is referred here.
No, he says that they moved the finance establishment A department for their views and necessary approval. However, finance establishment department after considering the same as regulated the grant of financial benefit.
Do you have that? Do you have anything in your file?
My lord, only the communication is with me, but my lord, that rejection order is not part of the.
Doesn't matter, the communication will give some reference to the proposal or something.
No, it's not there. ma'am.
This communication is to you.
Yeah, my communication. It says, my lord, the proposal was rejected by finance establishment department. When and under which, my lord, proposal or my lord, the endorsement, not a part of this.
Then how will you get a copy?
So I will provide it. I can have it from the department. Otherwise, that I can assure. At least
What
the
will
note-
you provide him?
The note sheet, my lord, it's in a proposal, it's form of a proposal. It will be
Hmm.
there in the endorsement or in a note sheet. That part I can at least provide.
Heard learned counsels for the parties. This writ petition was filed. The petition. Praying for a direction to the respondents to regularize the services of the petitioner as a principal of the medical college with retrospective effect from 1/10/2004, along with all consequential benefits, including salaries. Stop. The further prayer made in the writ petition was to fix the pay and allowances of the petitioner with effect from 1/10/2004 against the post of the principal, Medical College of the State, and to release the areas of pay and allowances with effect from 1/10/2004 to 31/8/2010. And a further direction to the respondent authorities to refix the pension and other pensionary benefits by reckoning the pay and allowances prescribed in the for the post of principal. Stop. The Joint Secretary, Government of Health and Family Welfare Department, Government of Assam, in its affidavit filed on 28/06/2012, made an averment that the proposal for the claims made by the petitioner was pending before the finance, is under process, was under process for giving financial benefits. Stop. The matter was taken up on several dates, but no conclusive instructions were placed before the court with regard to the status of the proposal sent on for regularization sent for conferring the financial benefits to the petitioner. Stop. Subsequently, on 21/07/2023, during the course of the hearing, the learned standing counsel for the Health Department, Mr. B. Gogoi, submitted before the court that the proposal, which was forwarded by the Department of Health to the Finance Department, has been rejected by the Finance Department. Stop. In this connection, an affidavit, additional affidavit was also filed by the Health Department filed on 1/8/2023, wherein at para 2, the following averments were made. Extract para 2. Stop. Today, when the matter is called up, no, right, in view of such circumstances, this court is of the considered opinion that nothing further survives to be urged in the present writ petition. You rephrase it, you say, in view of such submissions, this court is of the considered view that the writ petition need not be kept pending. The same can be closed with a direction to the respondent authorities to furnish a copy of the order or the office note wherein the proposal sent by the Health Department was stated to be rejected by the Finance Department. Stop. The petitioner will, is he required to file an application or you'll give it to him?
I will Lordship may indicate in order that I will provide it to you.
The learned standing counsel for the Health Department, Mr. Gogoi, has fairly undertaken to provide a copy of the said order or note sheet, extract of the note sheet to the petitioner. Stop. In terms of the above, the writ petition stands closed with liberty.